Well, hello there, and welcome to this employment law session where you get your questions answered, where you learn about employment law. My name is Lior Samfiru. They call me the employment lawyer. And of course, I'm here to answer your questions. I'm here to help you with your workplace rights. I'm one of the founding partners of Samfiru Tumarkin LLP. And I'm here to make sure that if you're in Ontario, if you're in BC, if you're in Alberta, that you get your questions answered. You know about your rights. We all have jobs. Of course, we all have time we spend working. And it's so essential that we know and understand our rights. It's not always that things are going to go well. We may have times when our boss may do something and we're just not sure if that's legal. We may have times when we're given an ultimatum. We don't know how to respond. Maybe our job has changed. Maybe our hours have changed. Maybe we lost our job, and all of that raises questions. What do we do? What do we say? What are our rights? Should I sign? Should I not? I think you get the idea. On this session, you have an opportunity to ask me your questions, to make sure that you leave here with answers so that you know how to deal with those issues. Of course, I've said this before, but it's so important that you remember. You have such extensive rights in Canada. We have some of the best employment laws in the world right here. Unfortunately, not too many people understand fully what those laws are, what those rights are. By watching this session, by listening to me on radio, by watching me on TV, you will get a lot of information. You will learn a lot about rights. So I want you to ask your question right now. Watching is good. You'll learn a lot just by watching. But isn't it better to actually get your problem solved? Maybe you've always wondered something about employment law, about workplace rights. Ask it. Don't wonder anymore. I'll tell you exactly what you need to know. And of course, beyond this session, if you want to connect with me and my team, here's what you do. It's so easy. You just go to employmentlawyer.ca. Again, employmentlawyer.ca. The address is right there, address on the screen. When you go to employmentlawyer.ca, phone number is there. Email address is there. If you'd rather fill out a form and have us call you, it's all there for you as well. And of course, you can learn more, a lot more about employment law there and about your workplace rights. I'll tell you more about the resources that we have available to help you. But right now, I want to start answering questions. So if you're watching, first of all, welcome. Thanks for joining me. Again, I'm Lior Samfiru, the employment lawyer. But now is your time to type in your question, hit enter. That way it will pop up on my screen. I'll read it, and then I'll answer it. Such an easy thing to do. Last few weeks that I've done this have been very busy, lots of questions. I hope to have even more questions today to answer. You have time. You don't have to rush now, so just ask your question. All right, so again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm going to get started to do what I set out to do, which is to answer your questions. In the meantime, ask yours. All right, we have a question on YouTube from DF. Can a severance agreement legally prevent you from saying anything about your former employer? Can you really deny or retract severance if a former colleague asks you what happened and you tell them? Well, a severance agreement is a contract, right? So ultimately, you and the company are bound by what the contract says. So if you sign a contract, the severance agreement, again, is a contract that says, I agree not to say anything about the company. I agree not to tell anyone anything about why I left, etc. Then you can't do that. Now, does that mean you won't get your severance if you break that? No, but there could be other legal action taken against you. You could get sued for breach of that agreement. So my best advice always, twofold. Number one, never sign that agreement without speaking to me, ever. I don't care what it is. I don't care how long you've worked. I don't care what you're offered. Talk to me. Chances are we can make that agreement much, much, much better. You're probably owed a lot more than what you've been offered, and there's probably other terms there that we can negotiate and make right. So that's number one, always. Number two is once you sign something, you have to live with it. Okay, so you can't sign something and say, it doesn't matter, I'm going to do what I want anyway. That's a problem. Okay, so anytime you have a severance letter in front of you, the first thing you do is you reach out to me. Well, no, first thing you do, maybe you tell your significant other. Second thing you do is you reach out to me. And to reach out to me, very easy to do, employmentlawyer.ca. Employmentlawyer.ca. So easy to remember. Wait a second, what is that? No, employment lawyer. Employmentlawyer.ca. phone numbers there, email addresses there, is all there. Okay, so thank you for that question, DF. Very important one, and hopefully you have some information. If you've just joined us, ask your question. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And as I've just done, I want to continue answering your questions. A couple more questions came in. I'm going to answer them right now. You have time, asks yours. Okay. Let's see. Paul has a question. What aspect of unilateral action impacts fraudulent activity for any entity or agency attempt to market not sure what you're asking, Paul. Sorry about that. Linda has our question. When is it okay for an employer to change your hours of work? I've had the same shift for 10 years, but I'm going to be moved soon despite my objections. Very good question, Linda. The answer is your employer is not allowed to make significant changes to terms of employment. So the question always becomes, what is significant? Well, I'll give you an example. If you work 9 to 5, now they want you to work 12 to 8, as an example. That is a big deal. That's a significant change. They're not allowed to do that. On the other hand, if you were working 9 to 5, now they want to make it 8:30 to 4:30, you probably won't be happy about that, and I get it, but it's probably something that they can get away with because it's not a huge change. It's not a significant change. So, Linda, when it comes to a significant change, they're not allowed to do that. That said, because I said they're not allowed to do that, it doesn't mean that there's a way to physically stop them from doing it. What it means is if your employer is changing your shift in a way they're not allowed to do, you can consider that to be a constructive dismissal. In other words, by changing your hours, your terms of employment, you can consider that to be a termination and require them, force them to pay you your full severance. And for you, it's probably going to be somewhere north of a year. I don't know how many years. I know you've been there at least 10 years, potentially more. So you could be owed a year or more of compensation. Because of that, that's what you have the right to do. Now, if that's your situation, if you don't want to continue working with those new hours, before you say constructive dismissal, before you do anything, I want you to reach out to me, okay? To connect with me as soon as possible, employmentlawyer.ca. One last thought, Linda. If your employer changes your hours and you just continue working, after a couple of weeks of doing that, you're going to be considered to have accepted that change, and then you can't do anything about it. So hopefully that makes sense, Linda. Any follow-up questions, you can ask them right now, or as I said, connect with me through employmentlawyer.ca. Okay, thank you for that question, Linda. Hopefully that's helpful. I'm going to continue answering. I'm Lior Samfiru, the employment lawyer. See how easy it is? Linda had a question. She asked it. I read it. I answered it. You can do the same thing as well. Make sure you get your question answered so that you feel better about your workplace rights. All right, let's see. We have a question on Facebook from Carrie. I am a residential house cleaner employee. I'm on a set salary every 2 weeks. Am I eligible to receive overtime pay when I work over 8 hours a day? Been there 2 years and have never received anything. Also, I'm required to pick up and drop off coworkers at their houses every day. Should I be getting paid for that travel time? So, first of all, I don't know what province you're in. No, I don't, because every province has different overtime thresholds. In Ontario, for example, overtime is paid if you work more than 44 hours a week. So it's not calculated daily. You said 8 hours a day. It's calculated weekly. So if you work more than 44 hours a week, you have to get paid for overtime. That means you get paid time and a half for any hour over 44. So that's now in some province, for example, in BC, they do have it calculated daily. So if you work overtime hours as it's defined in your province, then yes, you have to get paid overtime. Beyond that, yes, if your employer says, we need you to go pick up these people from work to work, that time, because your employer is requiring you to do that, counts as work time. So the time you spend traveling, picking up coworkers, it does count. So because of that, that would count towards your 44 hours, for example, if you're in Ontario. If your employer doesn't pay you overtime, you can claim back potentially 2 years to go back. Okay, you can call me. I can help you. For overtime, you can also go to the Ministry of Labor so they can help you. You can't go to the Ministry of Labor if you lost your job or if it's a constructive dismissal. But if you're owed overtime pay, vacation pay, holiday pay, for that you can. So hopefully that helps, Carrie, and makes you understand your rights. So thank you for that question. Very good question. Overtime should be paid, always. All right, let's see. So Linda had a follow-up question. Do I tell my employer about this constructive dismissal? No. As I said, Linda, if you want to pursue constructive dismissal, no, you can't tell you. Well, you can, but that's not going to do anything. You need to call me. We need to do this correctly. We need to pursue this correctly. So do not do anything if you want to pursue a constructive dismissal because your hours have changed until you speak to me. Again, to connect with me, very easy to do, employmentlawyer.ca. You see that on the screen right here, employmentlawyer.ca. You can do that today, sooner the better. All right, continuing to answer questions. Ask yours, by the way. Question on Facebook from Lily. What can you do if your employer lets you go while you're preparing to go on sick leave? So at that point, if you're going on sick leave, generally speaking, the answer is the same rules apply. They have to pay you your full severance. The fact that you're going on sick leave in and of itself doesn't change that. Means they have to pay your full severance, and that could be as much as 2 years pay, depending on how long you've worked there. Now, if you have a serious medical condition, you've told your employer you're going to be off for a while, and you believe that that's why they're letting you go. So they weren't necessarily going to let you go, but now that they know you have a serious condition, they're letting you go because of it, or at least some of the reason is because of it. That's illegal. That's a human rights violation. You cannot be let go because you have a serious condition, because you're going to take off on a disability leave. That's illegal. Your employer can't do that. So what do you do at that point? You talk to me, okay? And I can get involved and make sure that either your employer takes it back completely, or we get you compensation, which is severance plus human rights damages. So that's what you do. If the decision to let you go has nothing to do with your serious condition, then it's just a matter of severance. But whether it's just a severance issue or a severance plus a human rights issue, you have to call me. And the rule here is very simple. If you had a job and you lost that job, doesn't matter the reason, you call me, because you're going to be surprised by the rights that you have, by the extent of compensation that the law says you must be paid. Okay? Your employer's not going to volunteer to pay you that. Your employer may not even probably doesn't realize what they owe you. So how do we fix that? How do we get you what you're owed? You contact me at employmentlawyer.ca to do that. Very simple to do. And I'm here to help my team across Ontario, across BC, across Alberta. So thank you for that, Lily. Again, I'm Lior Samfiru, the employment lawyer. You still have plenty of time to ask questions. More questions have come in. I'm going to answer them. But please, don't give me 5 questions right at the end of the session, because then I won't be able to answer them. I won't have the time. Right now, you still have time. You can write the question, sit back and relax and let me answer it. So take advantage of that and ask your question. Okay, next question comes to us from Mick, who looks like he's joining us from YouTube. 25 plus years with the company. They're discontinuing my position. Offered 30-week salary continuance to my retirement date, then 39 weeks lump sum. This is also retaliation to a notice of harassment that I previously raised. So first of all, Mick, I'm not sure what you mean by retirement date. Did you tell them that you're going to retire? If you told them that, that may change the analysis, but the company can't impose a retirement date. You can work as long as you want, whether it's 65, 75, 85. So let's start with the easy stuff. And the fact that after 25 plus years, you're going to be owed more than 69 weeks. You potentially could be owed as much as 24 months, which is 104 weeks. So that's, I don't know, it's a 35-week difference. That's an 8-month difference. So right off the bat, I can tell you you're owed much more, significantly more than that 69 weeks. So yeah, that's a wrongful dismissal just on the severance piece. Beyond that, if you complain about harassment and that's part of the reason they let you go, that's illegal. That could be a violation of employment standards. That could be a violation of occupational health and safety. It could even be a human rights violation in some situations. Illegal. We call that a reprisal. You cannot be punished for standing up for your rights. So any way you look at this, Mick, this is illegal. All right. Even if the reason is completely legitimate, you're still owed more than 69 weeks. If the reason is not legitimate, it creates that much more of a liability for the company. So now that we know that, Mick, the next step, contact me, okay? We need to get this resolved. The good news is I'm pretty sure that once I do what I do and my team does what it does, we're not going to be dealing with this for a long time. We can resolve this quickly. Mick, you can connect with me today if you want. Very easy to do. Employmentlawyer.ca. Again, employmentlawyer.ca. Very important. Thank you for that question. Now, I talked to Mick about the severance that he's owed. I told him that he's owed more than 69 weeks, that he's potentially owed 104 weeks, which is 2 years. How do you know? How do you find out how much severance you're owed? How do you know if it's 69 weeks, 89 weeks, 5 weeks? How do you know any of that? Easy. I told you I'll give you some more tools. Here's the probably most important one. If you want to find out how much severance you're owed at any time, you just go to pocketemploymentlawyer.ca. Won't you know it? The address is on the screen right here, pocketemploymentlawyer.ca, and you click on the severance calculator. Ta-da, right there. It's that tool that allows you to find out, the severance calculator does, how much severance you are owed. Whether you lost your job after 6 months, whether you lost your job after 26 years or anything else, you can find out in seconds what is the right amount. Maybe you haven't lost your job, but you're curious. You want to know, hey, what would severance look like for me? How much would they have to pay me? Maybe you have lost your job, like Mick there, and you want to know if what they've offered you is appropriate. You can do that anytime. Just go to pocketemploymentlawyer.ca, click on the severance calculator. It's completely free, completely, no credit cards, nothing. It's completely anonymous. You don't have to put in your name or the company's name. You get the information, you can walk away, or if you want to, you can contact me also directly from the severance calculator. So always the first place you go to if you lost your job, and tell others about it. Maybe you're walking down the street and your neighbor is out and you're chatting with them and they told you they've just lost your job. Tell them right now, go to pocketemploymentlawyer.ca, use the severance calculator. Over 2 million people have used it. Now you can use it as well. Okay, and Mick just had a follow-up, says, I have an appointment set up with Brock. Brock is one of my colleagues, a fantastic lawyer. Okay, fantastic. Let's see. Next question comes to us. By the way, I'm going to continue answering questions right now. So ask yours. You still have time. You have plenty of time. So ask your question. Let's make sure you walk away with all the answers you need. Question comes to us from D. Taylor on YouTube. If you sign a contract for 2 years, can the employer terminate your contract after 8 months? Can they terminate? Yes, but here's the thing. If you sign a 2-year employment agreement or contract with your company and they let you go after a few months, they still have to pay you the balance of that contract. So using your example, if you sign for 2 years, they let you go after 8 months, well, they still have to pay you for the remaining 16 months. You don't have to work because they let you go, but they still have to pay you. I once did a case where someone signed a 5-year contract, was let go after 2 months. Well, guess what? They still have to pay him the remaining 4 years and 22 months on that contract. Silly for the company to have ended the contract, but that's what the law says. If you're on a fixed term contract, all right, for a contract of employment for a specific period of time, 6 months, a year, 5 years, if you're let go before that contract ends, in most cases, the company has to pay you the balance. Now, we have to actually review the contract. In some cases, the company may stipulate that they have an early exit, so we have to review that. But the general rule is if you're let go before the contract ends, they have to pay you the balance, and that could be a lot of money. Another reason 2,452, as to why you got to call me if you lost your job, no matter the circumstances. Hopefully that makes sense. Thank you for that question, Detailer. Happy to have had the opportunity to answer. All right, continuing to answer questions with me, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. R. Mac has our next question. I've recently been asked to take a new position, filling in for my boss. I accepted, but with the belief that we could discuss salary. My employer is now dodging me. What can I do? If they don't raise my salary but put me in a management position, is this a violation? So here's the thing. If you agreed to take on this more senior role, but you did not have an agreement with them as to salary, the company's not doing anything wrong. What you should always do in this situation is to say, I'll agree it as long as we agree now on what the salary is going to be while I'm doing that role, as opposed to, well, I'll do it hoping that they'll understand the value that you provide, and then they'll come to you and give you more money. So the only time the company is doing wrong is if they breach the agreement. If you had an agreement with them that they'll give you more money and now they're breaking that agreement, well, that's a breach of contract. That could even be a constructive dismissal. So the key is to be able to establish that we had a deal. I do this job, you pay me more. You broke the deal. Well, if they broke the deal, there's consequences. But if there was no deal other than you saying, yeah, I'll be the good sport and I'll take on this job, hoping that they'll do the right thing, they should do the right thing. But if there's no deal, there's nothing to enforce. So good word of advice, not just for our Mac, for anyone. If you have a deal with the company, maybe it's a verbal agreement, a handshake deal, send an email after confirming what was agreed to. So for example, if your boss says, hey, if you do a good job on the project, I'm going to promote you. Well, send an email and say, hey, boss, confirming that we agreed today that if I do a good job on this project, you'll promote me. You don't want your boss later to say, oh, I never agreed. If you put that in writing at the time, you're protected. Okay, so very important. Always in writing. Email works great. Our Mac, hopefully that makes sense. If you have a follow-up question, happy to answer it. Don't hesitate to do that. All right, let's see. Continuing to answer question. Let's see. Next question is from Rick. Rick is joining us on Facebook. Employer has laid off a 67-year-old employee that has been employed by the current owner for 18 months, but have been with the business for 15 years. Since being laid off, they have terminated employment with minimum termination as per the Employment Standards Act. So as I understand it, Rick, this individual has been with the company for 15 years. The company may have changed ownership. It was sold maybe. So here's the thing. He is a 15-year employee. So 67 years of age. I don't know what his job is, but he's probably going to be owed anywhere from 14 to 18 months of severance, so somewhere from 14 to 18 months. That's a lot more than his minimum entitlements under the Employment Standards Act. Okay, so he's been wrongfully dismissed. So this person has to call me. Keep in mind, at 67, it's going to be a lot more difficult to find a new job. It's more difficult at 67 than it is at 47. So it's that much more important that he gets the severance that he's owed. He doesn't want to be in a situation where he's accepted, 20-week severance when it should be 18 months severance. That's, 5 times the difference. So very, very important that he call me as soon as possible. The good news is, I'll tell you now, you can tell him, is that this should not be difficult to resolve. Generally, a letter from me, hopefully that's all it takes to get this done. So Rick, have him contact me. Okay, employmentlawyer.ca. Again, employmentlawyer.ca. You see that address on the screen right now. The way to reach out to me. You can get my phone number right there. My email address is there. Again, you can fill out a form and we can call him back. Easy to do. You did the right thing. You called me or you wrote here with the question. The next thing you need to do is to let this person know to contact me as soon as possible. Our Mac has a follow-up. Our Mac was talking about taking on a new role without more pay. I haven't really accepted a role as much as started taking on the work. I'm hoping it will change. Would it be unreasonable to ask for a prorated salary? So the question is not, is it reasonable? The question is, are they required to provide that to you? So the answer is no, unless there's an agreement to do so. I mean, the reasonable thing is for them to be fair to you and to compensate you properly. That's the reasonable thing. And hopefully if you ask them, they'll do the reasonable thing. My question is, or the things that I always turn my mind to is, can we force them? Can we make them? And in this case, unless there's an agreement, no. But you may want to tell them right now, if you just started taking on responsibilities and say, hey, thank you for this, but I'm not comfortable continuing to take on these responsibilities unless we can agree to a fair payment, so that they know that you're not going to continue doing that. If they know you're going to do the role anyway, then they have no incentive really to pay you more money. So keep that in mind, Armac. Any problems, you know how to reach me, employmentlawyer.ca. All right, I'm going to continue to answer a couple more questions. So thank you for those, guys. I see some more have come in. I'm going to try to answer them. Next question is from YouTube, from Cindy. If you have to leave a job because your employer is not willing to accommodate physical limitations, would you be owed any severance? I've been with my job for 25 years, but have a chronic conditions that affects mobility. Well, first of all, it's unacceptable that the company or employer is not willing to accommodate. It's not up to them. They have to accommodate. If it's at all possible for them to accommodate, they have to do it. So if they say, we just don't want to, we're not willing to, that's a human rights violation. It's illegal. So they're breaking several laws by doing that. On the other hand, if it's not possible, they want to, they've tried, they've made all efforts, it's just nothing at all that you can potentially do, well then, no, you don't necessarily get severance. You can stay on leave until something changes. Either their ability to accommodate changes or your medical condition changes, etc. But if you are not being accommodated, you need to call me right away. See how fast they start accommodating once they get a letter from me. Or if they still refuse, then yes, not only can you get severance, then you can also get human rights damages. But it's not up to the company to decide if they're willing to accommodate or not willing to accommodate. They have to do it. Okay, get that doctor's note. Make sure your doctor says what your limitations are. And if they don't accommodate, contact me as soon as possible through employmentlawyer.ca. Okay, JX2 has a question. If you were to switch from a unionized position within a company to a non-union position later, would your eventual severance be calculated from your original start date? Yes. So all the time with the company would count. So if you're now in a non-union position, but you used to be in a union position, and if you were just let go, your seniority for the purpose of calculating severance is going to include all the time you had with the company, all of it, union and non-union. And that's a good thing, of course, because the more seniority you have, the more severance is owed. So 5-year seniority generally is going to get less severance than 10-year seniority. You get the idea. So by the way, one thing I want to point out, of course, is that anything you hear me talk about today or you hear me talk about on radio or TV only applies to non-union employees. You hear me talk about severance, you hear me talk about constructive dismissal, etc. None of that applies to unionized employees. It only applies to non-union employees. If you're a unionized employee, your rights are very different. They're outlined in the collective agreement. Only your union is allowed and able to help you enforce those rights, and you don't have the same rights with respect to severance, constructive dismissal, etc. So hopefully that makes it clear. Guys, this is the time that I have for today. Now, my colleague Thielen is going to be right here, same time on Friday, this coming Friday, the 12th of April, 1 p.m. Eastern. He's going to be here answering more of your questions about employment law, helping you solve problems. But don't wait until then. Don't wait until I'm back here next week. If you need help, just like I've been saying, you can contact us today if you want. Just go to employmentlawyer.ca. Again, employmentlawyer.ca to get connected by phone, by email, whatever you need. It's right there. You have rights, but sometimes when you wait too long to enforce those rights, you lose them. So please don't do that. Don't let that happen to you. Let's connect through employmentlawyer.ca. Guys, thank you so much for the time today. I love the questions, fantastic questions. It's always a privilege to be here, to have the opportunity to help. I've enjoyed it very much. I'll be back soon. In the meantime, employmentlawyer.ca. I'm Lior Samfiru with Samfiru Tumarkin. I'll talk to you all soon. Take care.